Hello, Union family. I'm Charles with American Workers First. Welcome back to Union Facts Friday. Today we're talking about what is the National Labor Relations Act. The National Labor Relations Act of 1935, also called the Wagner Act, is the Magna Carta of American labor legislation. The main purpose of the act was to establish legal rights of workers to organize, join unions, and bargain collectively with their employer while also creating the National Labor Relations Board. The act was written by Senator Robert Wagner, passed by the 74th Congress of the United States, and signed into law by President Franklin Delano Roosevelt on July 5th, 1935. Happy Worker Independence Day. The act was designed to correct the inequality of bargaining power between employees and employers. Before 1935, workers could join unions and strike during disputes, but employers had the right to fire them for no other reason than their union membership or concerted union activities. The purpose of enacting this being to promote collective bargaining between independent trade unions on behalf of the workforce. The National Labor Relations Board is the primary enforcer of the act, having essentially two roles. They're there to oversee the process by which employees decide whether or not to be represented by a labor organization and prosecuting violations. The NLRB is designed to be nonpartisan, but the five-member board is nominated by the president and confirmed by the Senate, which, depending on who is in office, can have drastic impacts on decisions made. The National Labor Relations Act sets rules on collective bargaining, unfair labor practices being actions taken by employers or unions that are illegal under the NLRA or other labor laws, and the election of bargaining representatives. The act was fervently opposed by business groups when first introduced, who actually encouraged employers to refuse to comply and filed injunctions to disrupt operations. The campaign continued until 1937, when the act was found constitutional by the Supreme Court in the NLRA versus Jones and Laughlin Steel Corporation in a very close 5-4 vote. Chief Justice Charles Evan Hughes wrote, "The statute goes no farther than to safeguard the right of employees to self-organization and to select representatives of their own choosing for collective bargaining or other mutual protection without restraint or coercion by their employer. That is a fundamental right. Employees have as clear a right to organize and select their representatives for lawful purposes as the respondent has to organize its business and select its own officers and agents." The National Labor Relations Act is without question the most important piece of labor legislation enacted in the United States in the 20th century and continues to be the law of the land over 85 years later. Thanks for joining us on Union Facts Friday. We will see you next week, and until then, keep demanding that American workers get put first.